thinks about this. David, good afternoon to you, sir. And talk to me about your thoughts on this Strava app information coming in through a scientist or an expert as opposed to a representative from the app itself.
Yes, absolutely. This will, if brought in, be very damning evidence for Kellen Winslow, because it purports to show that he was actually riding his bicycle around the neighborhood at the time of Jane Doe No. 3's incident. So I've actually had this exact issue come up before, and I was told that I needed to provide a custodian of records to authenticate this evidence. So my evidence was excluded. I find it a little bit odd, and agree with your assessment that they're kind of avoiding this rule, which is a well-established rule in California, that if you're going to bring in this type of evidence, which we've all acknowledged is not hearsay because it is a computer-generated printout, that you need to do that through the custodian of records. So I guess after the break, we're going to hear a little bit from this witness who's on the stand and see what her expertise is. But yes, absolutely, this is kind of not going away from what is typically done in California with the custodian of records.
Because the witness on the stand, she seems to have the expertise to talk about cell phone technology and GPS and how that works. And that is fine. I have no problem with it. But the Strava app adds another layer to what is contained in the phone. And how it works should only be able to be brought out in front of the jury through someone who actually works at Strava. I think this is a big loss for the defense, and specifically, David, this is with respect to Jane Doe No. 3, who testified that she was gardening, she lived near Winslow, she was lived as a neighbor, excuse me, and that he came and he was in his cycling gear, he was very muscular, looked like he was fit, looked like he was exercising, and all of that, that app showing that he had ridden the bike for so many miles completely corroborates Jane Doe No. 3, especially because, David, as you remember, Jane Doe No. 3 did not identify Winslow in court, and her identification of him was vastly different than what he looks like. She said he was 8 inches shorter, and he was medium build, and you know the guy is like big guy.
Yes. Yeah, definitely. I mean, you hit the nail on the head. There were major issues with Jane Doe No. 3, and you said them all perfectly, is that she couldn't identify him at the prelim, she couldn't identify him in the six-pack lineup. She testified in trial that she didn't even really look at his face, which was kind of custom with her habits. And then here we are, we have this Strava app, which is going to be authenticated by someone other than the custodian of records. And this app is going to purportedly show that Mr. Winslow was riding his bike in the area in question at the time in question. So yes, this is going to be, if it comes in, and if it's not attacked appropriately through cross-examination, which it appears there could be some fodder for some good cross-examination, this could be very damning for the defense.
Hey, David, let's listen to what Jane Doe No. 3 exactly said with respect to how Winslow appeared during the alleged incident.
What was he wearing the first time you met him?
Lần đầu tiên chị gặp ông ta mặc cái gì?
Ông mặc cái áo thun không có cổ, không có tay, mà nó sát vô những cái quần nó ngắn, tới đây nó bó lại.
He was wearing like a very tight, no sleeve, no collar, and then the short, very tight shorts.
What type of outfit was that? The very tight shirt with no sleeves and tight shorts.
Chị cái kiểu đó là kiểu quần áo gì?
Cái loại mình là chạy xe cục.
The outfit that for cyclists, for people who are riding the bicycle.
So this outfit completely corresponds with the pictures that we saw in evidence, that were put in evidence of Kellen Winslow II in his cycling outfit, plus whatever the Strava app shows. The Strava app is going to show that he was cycling. So we look at these pictures right now, and I know Jane Doe No. 3 had a bit of trouble articulating, I think, perhaps because there was no adequate translation for how she was trying to describe these clothes, being tight, almost, like a leotard fashion. So there was a direct translation, but damaging enough, right, David?
Oh, absolutely. I mean, initially, Jane Doe number 3 was kind of good for the defense. She didn't get a good look at the assailant, the person who exposed themselves. The description was off, as we mentioned earlier. But now what we're finding is that some of the testimony that she's saying is being corroborated by what was found by law enforcement. I mean, specifically, we have this blue backpack, which Jane Doe number 3 mentioned seeing, and I believe that was found in one of the execution of the search warrants. And we're also getting a look at these tattoos. But I think Brian Watkins hit on an interesting point when he was cross-examining regarding the tattoos, and that's what Jane Doe number 3 described the tattoos as very blue. It appeared to me through the photographs, and it appeared to some of the other witnesses, that these tattoos were not blue. They were not bright blue. They were the kind of the standard black or greenish ink. So I mean, yes, there is some damning testimony with corroboration regarding the backpack and the outfit. We still have some issues with the tattoos. But overall, yes, Jane Doe number 3's testimony is being corroborated by these other law enforcement and what they found in the search warrants and some of the photographs that they took.
One of my colleagues also thought that tattoo exchange during the cross-examination was hurtful to the prosecution. However, two things. Number one, I don't think Jane Doe number 3 sounds like someone who is familiar with typical tattoo ink, as it was described, black or green tattoo ink. I just don't think she knows that. And secondly, people describe colors as different. I'm wearing a dress today. I think it's purple, but the girls in the makeup room, they think it's more blue. So I don't know, when colors are so similar between blue and green, blue and purple, I just don't think it was that big of a deal.
Yeah, I agree. It really wasn't that big of a deal. I mean, we have these kind of washed out tattoos that have been there for a while. I mean, I think the detective said it looked black to him. I think other people said it looked green. To her, it looked blue. So yeah, I really don't think it was too significant of a point, but it's just something the defense has to get out. And if she was describing like a bright blue tattoo, I clearly wouldn't think that would fit. So yeah, it is possible that Jane Doe number 3 is a Vietnamese, not really a big English speaker, and so it is possible that she just perhaps used the wrong word. But yes, I do agree with you that the tattoo is a definite problem for the defense.
Yeah, it was like a little point that they scored. Okay, great. But the big picture is she corroborates that the perpetrator had tattoos. Okay, David, shifting gears, another big moment I felt from this morning was when one of the criminalists, she testified that the front seat of the Hummer was not swabbed. And the significance of not swabbing the front seat of the Hummer directly corresponds with Jane Doe number 1's assertion that she bled in the front seat of the Hummer. So what is your opinion of that lack of swab?
Yes, absolutely. I would even go a little bit further. Jane Doe number 1's testimony wasn't just that she bled in the Hummer. She described, her words were, a heavy gush of blood similar to her breaking her water, in terms of a pregnancy. So, I mean, I would expect to find not just a few stains of blood, but based on her testimony, blood everywhere in that front seat. So for them to not even attempt to swab for blood, or I don't know if they ran one of these kind of luminol tests or phenolphthalein, but I believe that there was no blood found at all, or either none was looked for. So yeah, I think that was a definite, kind of lapse in the investigation there, and definitely something that will help the defense definitely down the road.
Okay, Simon, I'm going to need you to stick with me for the rest of the show here, okay? I'll get back to you at the courthouse. David, we learned just earlier from our Court TV legal correspondent, Chanley Painter, that the defense filed another motion today, one that we were all expecting, and that is the motion regarding, not regarding Jane Doe number 1. There was another motion with respect to the Jane Doe number 2. Thank you, Emily. Thank you. Okay, so Jane Doe number 2. There was a major motion that was filed regarding Jane Doe number 2 and whether the defense redness found in her vaginal and anal area, and that redness could be consistent with prior sexual conduct that she had 2 days prior, in fact, to the alleged incident with Winslow, from another person that she has come out and said, yes, I had sex with this guy, Bobby Guzman. The first hurdle is an alleged victim of a sexual assault from having to discuss her prior sexual contact or conduct.
Yes, absolutely. California has very strict rape shield laws that prevent defense attorneys from introducing prior acts of sexual conduct to prove that this victim was more likely to have consented. However, there are certain exceptions, and there's really 3 exceptions, and Chanley touched on one of these exceptions, and that's the exception to explain some sort of a physical injury. Now, I believe in the motion that you referred to that the defense filed this morning, they were saying that we're not introducing this evidence of prior sexual conduct with Bobby Guzman to show that, you know, she's a promiscuous person and therefore more likely to have consented to sex. They're saying we're introducing this evidence to show that these injuries that this SART nurse testified to were actually caused or possibly caused by Bobby Guzman. Now, Judge Bowman kind of was a little bit confused by that because Kellen Winslow has, as we testified to having consensual sex. But I think that there's another credibility of Jane Doe number 2. Jane Doe number 2, if you recall, about sex for money, and her testimony was, Kellen Winslow asked me if I would have sex for money, and I told him I'm not that type of girl. Now, if Kellen Winslow takes the stand, which I think is very possible, and it's starting to look more likely as this trial goes on, he might testify that not only was this consensual sex with Jane Doe number 2, but this was a prostitution John scenario. Now, if that happens, what we have here is an issue of credibility. We have one witness saying, I'm not a prostitute, one witness saying this is a prostitution scenario. So we would have a credibility issue here, and it is possible that if that occurs, we could see the defense attempt to argue that this semen found should be admissible to kind of settle this issue of credibility. So there's really 2 ways that I foresee. There's to ascribe the physical injury, but also to kind of clarify, you know, who's telling the truth here.
But if they go consent, then, and the judge mentioned this during the argument, wouldn't the redness be attributed to sex with Kellen Winslow II?
Absolutely. That's why I think the better avenue is not to introduce this prior DNA to explain the injuries, because like you said, there's consensual sex, so the injuries could be explained by either or. I think the better avenue, which we might see if and when Kellen Winslow takes a stand, is to kind of clear up this issue, because one of the exceptions to the rape shield law is to permit evidence to clear up an issue of credibility with the witness. So I think that, yeah, I don't think the redness is really going to be the way that this comes in. I think it might come in to kind of clear up whether or not this was a prostitution John scenario.
Okay, counselor, thank you so much. I'm going to ask you to stand by for more analysis later in the show. And now our such an impactful moment inside the courtroom. Do you agree, David, when this witness was, you know, we saw the pictures and we're inside the house and we see the blue backpack and then we saw the cycling shoes? What kind of moment is that when the jury gets to see it?
Yeah, I mean, absolutely. Jane Doe number 3 couldn't identify Kellen Winslow as the person, and she obviously, as we know, described someone a lot shorter, but it's looking like a lot of the things that she told police regarding, you know, what this person had, regarding the backpack and the cycling shoes, I mean, that stuff's found in his place. So, I mean, it remains to be seen, you know, how common these cycling shoes are and, you know, what type of backpack this is and how, you know, how widely prevalent this backpack is. But yeah, it's definitely damning, and the jury gets to kind of really corroborate Jane Doe number 3's story by pictures of things that they've seen in Kellen Winslow's house. So yeah, this is going to be an uphill battle for the defense, and definitely Jane Doe number 3 is appearing more credible as time goes on and as her story appears to be corroborated through the search warrants and what they found.
Okay, Simon, hang with me. I just want to give our viewers an update. We are